Hi, thanks everybody for joining today's session on the New Companies Ordinance. We'd definitely like to make this as interactive as possible. We've got a lot of experts who are, in terms of accounting, auditing, trust professionals, we've got all sorts of different expertise here. So more than happy for people to put their hands up and ask questions, or put their hands up and and make comments. I think that would make it a more interesting seminar. So feel very free at any time during the discussion to participate. This is a first, or it's actually the second of a series of workshops that we'll be doing. We did a put-en-noir version of this seminar 2 weeks ago. I didn't actually do that presentation. It was done by some of my colleagues. But we intend to continue to do a sort of a range of different topics, both in English and put-en-noir. So if you are interested in staying on our mailing list, please let us know, and we'll keep you informed about our further presentations that we're doing. The Companies Ordinance is obviously, pretty much relevant to anybody in Hong Kong. So that's a starting point. It's not just obviously advisors and practitioners. Pretty much everybody who's got a company in Hong Kong touches upon some of the issues that are relevant to this discussion today. The thing about this ordinance that's very interesting is that it's been in the making for over 10 years. So for a lot of people, they were probably quite interested when people started talking about it 10 years ago, and then moderately interested about 7 or 8 years ago, and then gradually the interest has dropped off. And then suddenly, before we know it, the law has actually come into effect. So, notwithstanding the fact that it has actually taken effect. So some people who have sort of not paid attention, haven't actually realised it has taken effect. And because it was so long in the making, it's actually quite a radical change. So there's a lot of things here that are radically different. I mean, essentially the companies law that we had before was, an old version of the UK law, pretty much dating back to sort of the 1950s versions of the UK companies law, which was something we were all very familiar with, but we now need to be immediately up to speed with what the new law is. Another interesting point about this law is that there are some parts that have happened automatically, which means that without you having to do anything, or without having to change your articles or look at your articles, the changes have been implemented. But then there are other changes that are effectively optional. So if you haven't updated your articles, then you can't actually avail yourself of the increased flexibility that's now been put into the law. So you can just continue as it is and ignore the things that you can do, but you may also want to consider checking your articles and considering updating them to give you the maximum flexibility available under this new law. In terms of what we're going to cover today, I'm going to cover off on some of the sort of generic stuff initially, sort of things like abolition of par value and new accounts reporting requirements and changes in relation to a memorandum and articles and things like that. But then I'm also going to talk in a little bit more depth about some more interesting things, which includes the new amalgamation process and the streamlined procedures for capital reduction, and also the streamlined procedures for financial assistance. Cliff, my colleague here, will then talk to us about some of the issues related to the change of things related to directors, codification in relation to directors' duties, changes in relation to corporate directors, expansion of the concept of responsible person. So it's obviously a huge topic, and we couldn't possibly touch on all the issues that are covered by this. So we've tried to focus in on some of the more interesting topics, but certainly if you've got more questions, come and see us afterwards. We're happy to sort of follow up on areas of interest with you personally. In terms of one of the first key changes is the abolition of the concept of Memorandum of Association. So it's just really, in a sense, a terminology situation. That it's no longer memorandum and articles in Hong Kong. It's simply the articles. So effectively, this has automatically happened. The memorandum, which sits at the front of your document, has automatically, in effect, merged, and it is now the articles. So the memorandum was always something that was a little bit antiquated. The memorandum typically set out the objects of the company, which, as most common law lawyers will know, actually didn't have any real effect on the ability of a company to do things. The way the law interpreted objects was to unlike a mainland Chinese company, any Hong Kong company can pretty much do any activity it wants, subject to separate licensing regimes. So what's happened here is effectively they've merged into one. In future, when you get your articles, it will be a single document called the articles. So you don't actually need to do anything here, but it could be a situation where you want to tidy up your documentation. You can just completely pass amendments to abolish the concept of memorandum if you want. So that's just simply a terminology thing to be aware of. Another change, which is a bit more than terminology, I mean it is a change of terminology, but it's a substantially more significant change, is that we've completely abolished the concept of par value and nominal value. So this is a process that's happened in other jurisdictions. It generally has become an antiquated concept to have par value in most places, and what this has meant is it's substantially simplified the whole regime around capital maintenance. So instead of having to worry about things about like, well, you've issued shares at this price, and the par value is this, and any amount above the par value is premium, and therefore you've got to put it in a share premium reserve, and then can you do this with it? So it's all simplified. Any cash that goes into a company is capital. There's no distinction between the types of capital. So there's no par value. So you're issuing 1,000 shares, there's no 1,000 shares of $1 each. It's simply 1,000 shares full stop, and the capital being subscribed for those shares is $1 million, and that becomes the entire capital. So it is a change of concept that's quite unusual because we are so used to the concept of par value here. There are transitional provisions to deal with documentation and situations where you don't necessarily reflect all of this language in your current agreements, for example. Equally, if your articles still refer to par value, it doesn't matter. This has automatically happened. So if there is par value in your articles, it's simply amended automatically. And effectively, that reference to par value is non-existent. So this is not an example of something where you actually have to amend the articles. This has happened automatically. So in terms of issue price, again, it's simply, which is a normal process anyway, the directors have to determine how much they're going to issue shares for, but they don't need to make any reference to the par value. They can just exercise their normal duties in the best interest of the company to issue shares at the price they deem fit. Common seal. This, again, is a sort of a technical sort of issue, but anybody who's been at a closing, a completion where you've had to deal with the antiquated metallic seals that Hong Kong companies have, and the reason we would use seals is when we execute documents as deeds as opposed to agreements. So more often than not, as lawyers would be in a closing meeting and the CEO of a company would be going, why on earth are you executing this as a deed? You're causing all this hassle for us by having to use this seal. And obviously the reason to execute as a deed is to ensure that the contract is binding. It's a whole other topic, but in the absence of consideration, there's a risk that a contract is not actually a contract. And so the way we lawyers usually recommend to people to get around that is we say execute as a deed, take any risk out of this, and then that will resolve the issues. So previously when we had to execute as a deed, we had to use this thing called the common seal. So it's a metal clunky device where you put things together. Quite often company secretaries and companies would go, I don't know, I've never seen it, I don't know where it is. And it usually causes a lot of hassle. So in some ways this is a good thing for lawyers in terms of closing meetings. So this is an optional situation. So you need to go back to your articles and see if, typically articles will say the company needs a common seal. So you actually need to go into your articles and get a special resolution to amend your articles to abolish the concept yourself out of your articles. And then once you've done that, you don't need the seal at all. You can simply execute using any two directors or director of secretary or sole director. This is the prescribed language in the company's ordinance for executing as a deed. So much simpler. No messing about with seals and red stickers. Just simply use the standard pro forma language. So that in a sense is something that's everywhere else in the world. Common seals, the UK, Australia have been abolished years ago. Increasingly, people are laughing at it. We're laughing at us when we said we needed a seal. So it's good that they've abolished that finally. Written resolutions. It's a little bit odd. They've put in quite a detailed procedure for written resolutions. I don't quite know why they needed to. After all, written resolution, if it's signed by all the shareholders, isn't that good enough? But what they've done is actually they've put in quite a complicated little procedure. This is to do with written resolutions of shareholders of companies. And there's a few little potential slip-ups here that you need to be aware of if you don't follow the procedures. And basically the procedures say, now this is written resolutions as opposed to just having a normal general meeting. So of course if you want to pass a shareholders resolution, you can have a general meeting in the normal way, and that's fine. It's no longer an EGM, it's just a general meeting. So you can just have a general meeting, pass your resolutions. If you want to do a written resolution, which obviously does happen sometimes in Hong Kong because we've obviously got shareholders in different jurisdictions, you need to go through this procedure. So the procedure essentially is that any director or shareholder with 5% can propose the resolution. That's not too radical. The next step is that it has to be circulated to all shareholders and auditors within 21 days. Now, failure to notify the auditors doesn't invalidate the resolution if it's subsequently passed, but it does potentially result in an offence and a fine. So the strict reading is that you have to give it to your auditors and your shareholders when you propose to pass a shareholders resolution, which can be a little bit annoying. Why do the auditors need to see every resolution that your shareholders want to pass? It's typically something that they might see at the end of the year when they're doing the accounts, but why would they want to see it as it happens? Secondly, once it has been circulated, it must be signed by all shareholders within 28 days. Now this is the real tricky one because the law specifically says if it's not signed by all the shareholders within 28 days, then the resolution is actually invalid. So that would actually mean that in a situation where you're actually, for example, you're wanting to check that a resolution's been properly passed, say you're at a closing meeting and you want to check that the directors have approved of the deal 6 months ago, potentially you should be checking that there's no clear discrepancy between the date of the first person signing and the date of the last shareholder signing. So if there's a 2-month gap and you're aware of it, then that definitely means that the resolution is invalid because there's a 28-day gap. Now whether you actually have to check that much, but if it has been dated, then that clearly would be an invalid resolution. So that in particular is a tricky one to keep in mind. And then the third step to this is once it's passed, it needs to then be circulated again, the signed resolution, back to all shareholders and auditors. Also, they need to be notified. That doesn't affect the validity of the resolution. So that again is just something that, well, it's not clear by the law. The law doesn't say, there are other sections that specifically say failure to notify does not invalidate the resolution. This particular section doesn't actually say that. So this requirement that has to be circulated to all notified, it doesn't actually say that if you don't do that, it will definitely not invalidate the resolution. So it's a matter of common sense. You'd think it would be pretty odd if it did invalidate the resolution, the fact that you failed to circulate it. But as a matter of good corporate governance, obviously you want to make sure that if you're the company secretary or you're checking your records, you want to make sure that it has been properly circulated again after passing. And this all sort of tells you that it might just be easier to go back to having general meetings over the telephone rather than circulating written resolutions and having to follow these 3 steps. So there's a few little tricky things there to be aware of. AGMs are now optional. So this essentially means that any private company, you can pass a resolution, the shareholders can pass a resolution to decide they don't want to have annual general meetings anymore. Doesn't dispense with the requirement to circulate financial statements. It needs to be done, can be done any time in advance of the upcoming AGM that the shareholders can pass this resolution. So this again could be simplifying things. Again, if you're going to do a written resolution for your AGM, you've got to go through the written resolution procedure, so maybe it doesn't actually simplify things at the end of the day. The final point is that any shareholder can then reinstate the process. So any shareholder can seek for AGMs to be reinstated. So any shareholder can make an application 3 months before the period before when the AGM is due to be held to decide that the AGM should be held. Simplified financial reporting. Now, there's obviously some accountants in the room, so hopefully you won't pick me up on anything I say incorrect here. But essentially, there's now two different layers, or two different regimes for different companies. So there's the ordinary company, and then there's eligible companies who can participate in simplified reporting. So what's happened is that they've provided a lesser standard of reporting to these smaller companies, and at the same time they've increased the obligations on larger companies in terms of their annual financial reporting. So the logic here obviously is that they're trying to reduce the burden on smaller companies, and they've basically implemented a number of tests. And essentially the tests are that if you're a smaller company, you've got to meet two of these three size tests. And so this, say you've just set up the company, it's your first year, it can be assumed that, you know, if your revenue, and you meet that test in the first year, that you're a small company, and then it's not until you have 2 consecutive years going forward where you exceed the small company thresholds that you have to then go to the large company reporting standard. Equally, there's another scenario where there's a slightly higher threshold. And basically a larger company being a company which, the same test, but it's 200 million revenue, 200 million assets. So essentially the same test, but with shareholder approval, you can also apply for the simplified reporting. So, I mean, there's probably quite a lot of companies that fit under that simplified reporting regime. So it is worth keeping that in mind, especially if you're running a business under this size. Presumably your auditors will let you know that you don't have to comply with the higher standard reporting anyway. But it's something definitely to keep in mind, especially if you're advising clients as well. Compared to, say, the British Virgin Islands, where there isn't any auditing requirement at all. This is still more burdensome, but it's making it a bit easier for smaller companies. So for the smaller companies, they don't have to do a business review, and I'll explain what a business review is in a second. It's a new concept that didn't exist under the previous law. So it's a new requirement for the ordinary companies, the larger companies, to fulfil. And it's a little bit more analogous to what listed companies need to do. We'll explain a bit more detail about what a business review is. But for the eligible simplified companies, there's no business review. There's reduced disclosure requirements. So in terms of what needs to go in the director's report, substantially less requirements in terms of material interests in transactions with the company that you need to disclose. Your arrangements in relation to your share dealings with the company doesn't need to be disclosed in the same detail in the director's report. But quite interestingly, so these standards have been dropped for reporting purposes, for annual reporting purposes, and for audit purposes, but at the same time, Cliff comes to talk. He'll talk a bit about how some of the directors' duties have actually been codified, in some places made a bit tougher. So it's a little bit inconsistent that they're reducing what you need to put in the annual report, but at the same time, the stuff that you might need to do prior to a board meeting is a little bit tougher. Doesn't really make a lot of sense. I would have thought, keep it in the director's report and wait until the end of the year. But it'll, so it's a little bit inconsistent, I think. The other factor is that the auditors don't actually have to express a view, an opinion as to whether financial statements are a true and fair view. So that's a pretty big change. So if you're an M&A lawyer or you're looking to do an M&A deal and you're relying on that rep and warranty that the accounts are true and correct, or your client's just saying, "Look, we'll rely on the audited accounts," you might not want to. You might want to actually dig a bit deeper, and those accounts may not be good enough if you want to buy this company. You may want the auditors to issue another report, or you may want to have someone else come and look at the financial status of the company. So, I mean, that's a big change, that the auditors can, they don't have to express this opinion. Typically when they have to express this opinion, I'm very interested to hear any other views, but when they express this opinion, if they disagree with this, they'll typically have to, issue reasons or explanations why they don't disagree with it. Now they don't even have to give that view; they're just saying something else. There are standards in relation to small and medium-sized entity financial reporting. So there's obviously a lot of detail about how auditors would consider all of this. Enhanced financial reporting for everyone else. So for the companies that don't qualify to be small companies, there is more than there was before. There is enhanced reporting requirements. So they've now got to prepare a new business review section of the director's report. So this will be quite a foreign concept to unlisted companies. I'm sure there's a lot of big family-owned companies that are very substantial that haven't had to prepare a report with this kind of information in it. So that's quite different. So they probably, they'll need guidance as to how to do that before they issue the report. There's a slightly expanded disclosure requirement in relation to equity-linked agreements. So it's just slightly broader. So equity related to the company. So in terms of what the directors have to disclose in relation to the equity arrangements they have with the company. So it's a little bit broader than it was before. And then slightly higher standard for the auditors, I think. The auditors have to report on any inconsistencies, which, again, I'm very interested in views, but I would have thought that it would have made sense that an auditor would have identified any inconsistencies in their report anyway. If they've got a director's report and they're doing the audited accounts and there's an inconsistency, you would have thought that the audited accounts would highlight that. But it's now a statutory requirement that they must report on any inconsistencies. So a slightly higher threshold for the auditor's report that needs to be issued, and therefore, there's maybe even more value in the auditor's report for these largest sized companies. An area which is a bit more, well, I think is of quite a bit of interest is amalgamation. So amalgamation as a concept is sort of very unfamiliar to people in Hong Kong. It's a very common concept in the US. And what amalgamation or merger, it essentially means you have two companies and they effectively come together as one entity. A little bit like two cells through osmosis coming together into one being. And what it means is that everything that is attached to each of those individual entities is combined. So this was a concept that did exist under the previous law, but was really never used because it required court approval. But they've now introduced a process that makes it much easier, but it limits it to intergroup mergers. So there could be some potentially interesting things here for creative accounting practices. If you think about it, and you'll see there's some limitations on some of the extra things I'm suggesting, but if you think about it, you've got a company with a certain amount of liabilities, a certain amount of assets, and you put them together, that suddenly is a very different complexion. And there could be some creative things that might emerge, provided you meet the requirements that we'll go through in a second. So, and it also could be an easy way of dealing with sort of housekeeping as well. You do often get clients coming to you and saying, well, we've got a lot of companies in our group and we want to liquidate some and tidy this up. We've got too many companies in our structure. This could be an alternative, simpler way to tidy things up. If you simply, a normal way to do a restructuring, if you've got a group situation, would possibly be to cherry pick and transfer certain assets to certain companies. You would then still need to go through, there's a regime in Hong Kong that deals with transfer of business called the Protection of Creditors Transfer of Business Ordinance. So you need to go through that ordinance, and then you need to liquidate the company that was left at the end. So this is actually a fast-track way. You can have two companies and pull them together, and you don't have to worry about incurring costs liquidating one of the entities or go through the same transfer of assets process. There's two scenarios where you can do this under the law. So the first one is vertical amalgamation. So you've got a situation where you've got a holdco which owns 100% of sub 1 and also owns 100% of sub 2. So they have to be wholly owned subsidiaries. And then the merger would be that sub 1 is merging up here with holdco, and they become one entity. And the way that it all works in this particular structure, that the holdco, say the holdco has a particular company number, the merged entity would have the company number of the holdco under the way the forms work to do this. And then this entity, obviously the capital needs to be adjusted. What would actually happen in this particular vertical amalgamation is that the share capital would stay the same. So obviously there'd be auditors and accountants involved through this whole process, but the capital would stay the same in this merged entity. Effectively, there's a thing called a negative merger reserve to stop double counting. Because if you can think of a situation where you have lots of subsidiaries and you merge them up here and you wanted to keep artificially adding up your capital. So effectively, this capital of this company is cancelled, the shares are cancelled, and then it merges into one entity and then carries on like that. So in terms of things like contracts, contracts would pass to the new merged company. So typically, this is something that affects all of us. Typically a contract, any contract that we sign in Hong Kong typically has a non-assignment clause. You can't assign your rights to another party. It also may have a change of control clause, that the party that you're contracting with can't change its shareholding. There are different situations where you can argue that the merged entity does not contravene either of those clauses. So you could sign a contract with Exco here, you're the third party, you have a no assignment clause, you have a no change of control clause. Unbeknownst to you, they decide to merge. And then suddenly, the company that had 20 billion assets is now only 15 billion assets because it's merged with an underperforming subsidiary. So there is sort of potential situations that could arise. I mean, you definitely do see in US contracts a prohibition against merger. So it's something that should really now appear in all Hong Kong law contracts as well. If you want to make sure there's no restructuring or merger of the entities that you're signing a contract with, you need to be aware of this. The second scenario that's allowed under the law is horizontal amalgamation. So this is, in a sense, a bit simpler. You've got two subsidiaries wholly owned, again, by the holdco. They merge together to become one entity. So in that scenario, the capital would aggregate. So you have to nominate which one of those companies is going to be effectively the dominant company, which will carry, say this is company number 3, this will keep the company number 3 for this. And then what will happen is, effectively, the shares are cancelled at this company level, so the shareholding stays the same here in terms of the number of shares issued, but as we mentioned, there's no par value or any of that sort of concept, it's just a concept of aggregate capital now. So what will happen is, for these two companies, the capital will be added up. So the capital will be effectively doubled. So say 1,000 shares here, 1,000 shares here, $1 million capital here, $1 million capital here. You'd end up with 1,000 shares still, because it's one of the subs, and then you end up with capital of 2 million. So I'm sure there could be some creative things that can be devised in relation to this structure. The process, it's not any company. It has to be, as I've mentioned, within the same group. The directors must also make a solvency statement. So solvency statements are also relevant in relation to capital reduction as well. Solvency, if you make an improper solvency statement, you're potentially liable, there's a potential criminal offence, and 2 years jail, and only a $150,000 fine. So solvency statements need to be made carefully, and then the idea behind these processes is obviously not to cheat people who are owed money. You could see a situation where one company owes a lot of money, or has a lot of liability, and they want to put it across to another company Or you know, there could be situations where people are seeking to defraud creditors in this kind of restructuring. So you can only do the restructuring if you meet these requirements. So one, the directors must say that both companies are solvent. The applicable directors must say each of the companies are solvent, they're being merged. And you also have to notify creditors. They have to be notified within 5 weeks. They have 5 weeks to object. Notices have to be published, government gazette, newspapers. So it's slightly different. Under the old law, you needed court approval. You also needed a solvency statement. You also gave creditors a chance to object, but auditors also had to confirm that the amalgamation should go ahead. So the new process is no court approval, but other elements are a bit similar. So essentially, it can be done quite fast. So it's only 5 weeks to object to the process. So as I sort of mentioned, you know, could be potential things with creation of realised profits and loss. I mean, so going back to that last point, that must pay debts, not prejudice creditors. In terms of that, I mean, that is probably the biggest situation that would stop you, playing around too much with realised profit and loss. So there is the directors do need to make that covenant that they won't prejudice creditors. In terms of tax treatment, I've read a couple of articles that have been written by accounting firms, a couple of them very negative, and saying it's all very unclear until the government issues us a direction. It could be liable to stamp duty, but that doesn't make any sense to me. There's no stampable transfer of shares here. They've also said that there could be potential issues of capital gains tax in relation to if you've got other foreign subsidiaries. So there's always a risk there where you've got a change of ownership of subsidiaries, say in Australia or India or China. If there's a change of holding company, it could trigger capital gains related tax in those places. So there isn't currently a lot of tax clarification on how this will work, but the logic should be that it shouldn't incur stamp duty, but the IRD haven't actually issued a notice confirming that at this point. But it'd be very interesting to do a proper analysis of that position, whether any law firms or barristers are prepared to sort of just go ahead and say you can do it. I just don't see that there would be stamp duty payable on a intergroup merger. I don't see how it should work like that. But at this stage, it's largely untested. The laws only come into place in March, so we'll have to see how it will work. And as I say, I think some of the accountants have been very, very cautious in their public advice. Maybe they might be more cautious if they're instructed. Next topic was court-free reduction of capital. Under the old law, to reduce your capital, you had to actually get a court approval. So, as a general sort of comment, often we would suggest to clients, you're thinking about how to put cash into your Hong Kong company. Do you want to put it in a shareholder loan or capital? They're the two key ways. And in terms of how we would weigh up the pros and cons and give them a list of pros and cons, we'd obviously quite often tell them, well, put it in as capital if you really want to, because you want a capitalised company which has cash and looks more solvent. But keep in mind that you can't get that cash out easily. So what we would usually do is generally suggest you put it in a shareholder loan, which shareholder loans in Hong Kong can be played around with and very flexible, and there's basically no issue with paying shareholder loans anytime you like. So what this new process does is it does make it easier for companies to put in capital, and it capitalises the company, obviously makes it look more valuable, but they do then have the stronger ability to get the cash back. And it's certainly much easier without having to go to court. And equally, under the old process, they also had to get the auditors to give an assurance that cash should be repaid. So now the test is much simpler. It's a solvency test, the same as the one for amalgamation. So it's still subject to the 2-year jail term if you give a false solvency statement. Special resolution, publication of notices, again, government gazette, newspapers, 5 weeks to object for creditors. The special resolution has to be passed within 15 days of the solvency test being done. So there's some sort of strict time requirements. But then, actually, apart from that, the process is much more streamlined. Still not as flexible as putting cash in as shareholder loan, but it is something to keep in mind that companies can put in the cash much more readily as capital, and that obviously can help them in terms of having a more capitalised company if they're doing investments into mainland China, or if they're entering into loan arrangements with local banks, all those sort of situations that could make it actually easier. Financial assistance. So the financial assistance concept is something that actually I think most people sort of expected that it might be abolished under Hong Kong law. It has been abolished in most other common law locations. So it no longer applies in the UK, no longer applies in Australia. Essentially, the concept of financial assistance, it's a very specific prohibition. And essentially what it is that if you are buying the shares of a company, you can't use the cash of that target company to finance the acquisition. So you can't take cash out of the coffers of the target company to basically pay the seller. And that could be directly cash, it could be other forms of interest, it could be debt, it could be other forms of help, even legal advice, paying for legal advice, could be financial assistance. So typically when we do sit down with UK lawyers, and we're trying to pick issues that might be different from the issues they would pick when they look at contracts, this is one of the first ones we look for because this is so different to English law, and it does actually have a substantial repercussion because it is a criminal offence, and it does carry a 12-month jail term. So it does seem innocuous, but it is a proper criminal offence, so it is something that's important to pick up on. So what they've done with the new law, under the old law, to get out of that was a reasonably complicated whitewash procedure. Not overly complicated. So the key was always to identify the financial assistance and then go through the whitewash procedure, which involves special resolution, a director's statement regarding the purpose of the financial assistance, and also commitment that the company undertaking the company can pay its debts. They've introduced a different type of whitewash procedure, which is much more streamlined. And what they've also done is they've said that they've made it clear that the law is that if you do financial assistance, yes, the people who are doing it, the directors might go to jail, but the actual transaction involved is okay. So it doesn't potentially invalidate the transaction. So the situation, of course, always arises if you're acting on the other side of a transaction. You're acting for the purchaser. Acting for the purchaser, and then you're aware that there may be financial assistance going on. Do you actually tell them, given that it won't potentially validate the transaction now? Cliff will also talk to you about the expanded concept of responsible person. So that could be a reason why you should tell them, apart from potential ethical issues. But the responsible person concept is actually broadened the potential for directors' liabilities. So directors' liabilities are now go beyond just directors. I mean, there was a concept of shadow directors before, but it now goes to a broader category of people. So this is an example where potentially if you were involved in the management of the business or involved in something to do with the operation of the business, then you should be conscious that you don't want financial assistance to occur. It's not just the directors who are potentially exposed. So in terms of the actual process to whitewash it, it's not whitewash now, but to authorise it, you've got to get directors' resolutions confirming it's in the best interest of the company, that it's fair and reasonable. You've also got to get the same solvency statements from the directors, again confirming that it's okay. And then there's a variety of different scenarios where you have different approvals by shareholders and directors. Essentially, if it's directors approving it, it can't involve more than 5% of the funds of the company at that time. But there are different situations and different thresholds for if all the shareholders approve it. So it is a much, much easier process than before. But again, you've still got to be aware of it because they haven't changed the criminal offence. I mean, they've increased the fine from $125,000 to $150,000, but the jail term is still there. Unfair prejudice. This is obviously an area which is more relevant to our litigation group. Essentially, under the law, shareholder, if they feel they've been unfairly prejudiced, can take action against the majority shareholders or the other shareholders alleging unfairly prejudicial activity. There's a lot of case law in this area. But what's now happened is they've basically clarified a couple of points. So there hasn't been extensive changes, but what they've clarified is that the unfair prejudicial conduct can include threatened proposed acts or omissions. So before, the way that the wording was written, it had to be things that had happened in the past. And then what they've clarified is that it can be threatened actions. And then they've also clarified the scope of order that can be done in terms of remedying that unfairly prejudicial act. So before, courts could only have a strict power to sort of put the parties back, to deal, the wording actually was bring an end to the matter complained of. Now the courts have actually got a broader scope, so they can actually go in and definitely fix up the situation. They can say, well, okay, we've got to transfer the company across to one of the shareholders. That's the only way this is going to be resolved. So it just clarifies some of the position that was in case law, but was a little bit unclear. So I think I'll pass you now over to Cliff, and Cliff will talk about directors' duties and corporate directors, responsible persons. And then at the end of that, we might talk through a few more examples, but also if you've got any issues or questions, we can take those then. Thanks.
Hi. I need to make sure my voice reaches the end of the room. It's a bit difficult to be talking about responsibility at this time of the day. I was born in Sydney, and it's about this time of the day when we get out of the office and go downstairs to be irresponsible. But responsible person is a theme amongst the company's ordinance to enhance corporate governance and to also dig down right to the roots where they can find someone to pay a fine and sit in jail. In the old company's ordinance, they defined a responsible person as an officer or shadow director who knowingly and willfully authorizes or permits a default, refusal, or contravention of the company's ordinance. And as any lawyers or normal people would know, this part, the intention part, is very hard to prove. So they found it very difficult to actually catch anyone. And in the new company's ordinance, the legislators decided that they must enhance and widen the scope to include any director, shadow director, or officer who authorizes or permits. So they removed the knowledge requirement. And a lot of people may unknowingly or recklessly contravene the company's ordinance, and now they are responsible. And so that brings me to the importance of directors today. It's quite funny. A few years ago, I was working on a lot of company listings in Hong Kong, and I kept seeing an independent non-executive director at each of the companies I was listing. So he was acting as a director for several companies. This is quite popular in Hong Kong. You come across many people with business cards with a list of companies at the back. After the promulgation of the new companies ordinance, this has become quite rare for the reason that directors' duties are being taken more seriously by the listing committee, the exchange, and the company's ordinance. Before the new company's ordinance was in place, we relied on old case books to determine how responsible a director should be. And basically the test was as responsible as the director is, or as responsible as he can be. So it's very subjective. Each director has different skill sets, upbringing, and if he didn't have a university education, then you could only raise the bar to a certain level. If he was a certified public accountant, you could raise the bar very high. And Hong Kong decided to take a dual approach to this. So we kept the subjective test. So if any director is qualified finance person or legal person, he can be held to a higher bar. But the minimum bar is raised to an objective test, to that of a reasonable director. So attend director trainings if you're a director, and we also host some of these director trainings ourselves. So that's very important. The company's ordinance issued a new guide for directors' duties. You can download it from their website. Corporate directors, a lot of trust structures or corporate structures use corporate directors as directors for Hong Kong companies before. In fact, the problem was so bad that back in the old days, good old days, you had corporate directors who were directors of corporate directors who were corporate directors of other corporate directors. And sometimes you ended up in a circle. And so this was one of the things that we used to actually get out of this loophole. And now we only allow corporate directors for private companies. And if you do use a corporate director, you must have at least one person who is a natural person who can actually sit in jail and pay a fine. Very consistent. Declaration of interest, this gets onto the particular day-to-day goings of enterprises in Hong Kong. Declarations of interest. First, we have to declare to the board. This is from the old to the new, no changes, but we have a broadening of the scope. Instead of just contracts, we have to declare interest in contracts, transactions, and arrangements. That closes a lot of loopholes. And instead of just saying whether our nature and the interest is monetary or in the form of shares, we need to say how many shares, what percentage of shares, or how much money is involved. And they've babysat us through how we can make this declaration. We have to declare through directors' meetings, obviously, or written notice to the board, or a general notice. For example, you have a continuing relationship with one of the suppliers, and so you can write a general notice to the board saying that you have this continued relationship, so you don't need to mention it every time that you have a board meeting. And now we've also included agreed electronic means because everyone uses WhatsApp, WeChat, and email, so those are included in the forms of communication. What the statute doesn't say is whether you can vote or not in the form in participating in these meetings. Each of the individual corporations' articles will mention whether you can vote or not, so please check those. And you should also declare your interest to shareholders, because this is a common law requirement that has not been overridden by the ordinance. Ratification, quite simple. Shareholders can say okay, they can okay anything that a director does, except illegal things. I'll go on to these more complicated things, such as loans and quasi-loans. A lot of companies, in fact, most of the companies in Hong Kong are family-owned, and that gives a lot of leeway for companies and their managers to mishandle the finances of the companies. They can, make loans to buy cars and various luxuries for the directors' wives, girlfriends, etc. And so, in the new companies ordinance, we have approval exemptions for loans and quasi-loans, so that members need to approve these transactions for companies. And in the old companies ordinance, any member can approve this, as long as it passes the majority. In the new companies ordinance, only disinterested members can pass these resolutions. So that closed another loophole. Two other exemptions are introduced. So if your loan or quasi-loan doesn't exceed 5% of the share capital of the company, you can do it. Or if the funds are being used to defend a director in criminal, regulatory, civil proceedings, not involving dishonesty, you can use those funds as well. So, some useful exemptions.
Given the point you made that so many of these companies are family-owned, what do you have if you have a company where there are no disinterested members?
If there are no disinterested members, they can use the written resolution form whereby all shareholders ratify or pass a certain conduct. Right? So majority wouldn't work. Long-term service contracts are prohibited by the new companies ordinance. This mirrors our listing rules, which already prohibit long-term service contracts. And now you need the shareholders' approval to do this. Otherwise, we might have some lazy or non-performing directors sitting for a very long time. Next is for directors' loss of office. I think this is quite interesting because I was working on a deal where people were trying to encourage directors to leave by giving them so-called severance payments outside their contract. In fact, that was in contravention of the company's ordinance. So, unless members' approval is obtained and unless the sum is less than $100,000 or in discharge of existing contract, for example, a golden parachute term or things like that, you need the members' approval to approve a payment for a director's loss of office. The consequences are quite interesting. So, if the law is contravened, the payment for loss of office is made, the director who received the payment holds the payment on trust for the company, so the company can at any time trace the payments back. And any director who authorized the payment is liable to indemnify the company for a loss. And that's a lot of money if the company habitually does this kind of payment. Each of these directors' duties and prohibitions are cumulative. So, for example, you have a payment for a director's loss of office and a declaration of interest and a long-term service contract for the same person. They need to go through resolutions to approve each term of the statute and to also hold the shareholder meetings or written resolutions to approve each term. That brings me to the good conclusion.